Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. This week's lecture, or this morning's lecture, is going to cover Chapter 15, where we are going to look at issues relating to counterterrorism and how those issues kind of correlate, if you will, with counterterrorism. So with that said, let's go ahead and jump into our lecture this morning. So in October 2001, the U.S. Congress passed, and then President George W. Bush signed into law a new law to assist in combating the threat of terrorism. And this new law was titled the USA Patriot Act. If you want to know a little bit more, I've thrown a couple links to videos as I typically do. So I have a link to the USA Patriot Act if you want to learn a little bit more by watching, say, a 5 or a 6 minute video. So continuing with the Patriot Act, that's not its real name in essence. That's kind of the short acronym. So the actual name of this new law is the United and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act of 2001. Now, that's a lot, which is why we typically use the acronym, the USA Patriot Act. So what this act does, and we're going to get into it a lot deeper as we go through the lecture, but it really does define some new federal criminal offenses relating to terrorism, but it also introduces some reforms to criminal procedure to make it a bit easier to investigate and detect acts of terrorism. Now, because this law was only set for a particular time period, you're going to see that the Patriot Act actually is going to sunset or expire a few times. So in 2005, certain provisions of the USA Patriot Act were set to sunset or expire. So the revisions were again passed into law in March of 2006 by President George W. Bush. And then again, provisions of the Patriot Act were going to again sunset or expire in 2011, and therefore Congress acted to review, amend, and reauthorize it. So you can see that it only lasts for a certain kind of block of time, and it's had to be kind of revisited, and maybe some amendments were made, and then it has to be reauthorized and put back into law. So finally, on June 2nd, 2015, President Barack Obama signed the USA Freedom Act into law. And this act basically took the place of the Patriot Act. And of course, that's just the acronym, the USA Freedom Act, because the actual name is United and Strengthening America by fulfilling rights and ensuring effective discipline over monitoring act. So that's a lot. And again, typically, I've got some video links that you can look at so you can sort of see the difference and look a little bit more closely at the timelines. But this USA Freedom Act restored and modified several of the provisions of the Patriot Act, which had actually expired the day before. So this new act imposed a few new limits on some things, like on the bulk collection of telecommunication metadata on U.S. citizens by American intelligence agencies. So there are some limitations, and also including another agency called the National Security Agency, and we'll talk about them later. It also restored and authorized things like roving wiretaps and tracking of lone wolf terrorists, and we'll take a look at that a little bit closer. So again, here's a video to the Patriot Act, a very short video describing the USA Freedom Act. And again, you can look at some of those timelines. So I think it would be good that before we jump into our lecture a little bit further, that we define what terrorism is. Just the basic definition. So there are a wide variety of definitions of terrorism. And the U.S. State Department follows U.S. statutes and defines terrorism as premeditated or politically motivated violence. But let's look at a couple of different definitions. And what I want you to pay attention to would be the kind of the crossover or some similarities. So generally, terrorism is defined as the deliberate, unlawful use of threats, force, or actual violence to instill fear, or intended to intimidate or coerce individuals, groups, or governments to change their political, social, religious, or ideological basis, kind of how we look at things or how we think. So as we look at some other definitions, you can see some of the things that are similar. The FBI's definition, terrorism includes the unlawful use of force or violence. Well, we saw that in the first general definition, against any person, property, to intimidate or coerce a government. We saw that. A civilian population, or any segment thereof, in furtherance of political objectives. So you can see some things that are starting to be similar. And the 22nd U.S. Code defines terrorism as the premeditated, politically motivated violence perpetrated or carried out against non-combatants. So not like a war against the average individual, these types of targets, by subnational groups or clandestine type groups. So again, the U.S. Department of State follows a lot of the U.S. state statutes and defines terrorism as premeditated, politically motivated violence carried out against that non-combatant targets by a subnational group or clandestine group, usually intended to influence an audience. So, and a little more, international terrorism is terrorism involving individuals from more than one country, or terrorism that involves the territory of more than one country. So, again, we see a couple of different definitions. So, the first part of our chapter, as we start to get into this, is we're going to look at several provisions of the Patriot Act that are relevant to criminal procedure. And you can probably tell, because there's going to be some issues relating to, let's say, evidence and search and seizure and obtaining information. So things like electronic surveillance or sneak and peek warrants, information and records. And then again, how do we define what a non-citizen is? And we'll talk about how that fits in with the conversation. And the Patriot Act is again only one one of a number of procedural tools that are relied on to combat the international terrorist threat. And some of these counterterrorism mechanisms that we'll look at will be material witness warrants, or listening in or monitoring attorney-client privilege, or the length that we can go to in order to conduct interrogations. And then finally, we'll look at military commissions and how they kind of fit in. So let's kind of get into this a little bit deeper now. So the United States is a government and country based on the rule of law. Now, in war or in times of national emergencies, typically legal standards have historically been loosened a bit in order to combat the threat of terrorism. And several judges and even legal scholars have noted that the Constitution is not made to be like a suicide pact, and that the first priority of government should always or must be to protect the American people. Now, while that sounds good, let's kind of look at the other side of the coin. So on the other hand, there is a danger that fear and insecurity may lead government officials to overreact and to therefore sacrifice some of the very liberties that are the core of our democracy. So once again, and you've seen this in other chapters that we've covered, the challenge to all of this is to strike the appropriate balance between combating the threat to national security and protecting our civil liberties. And here's kind of like an example, if you will. And think of this in relation to maybe 9/11. So suppose the government found out that a captured terrorist knew the whereabouts of a dangerous explosive device that was set to go off and it would kill thousands of innocent people. Would it be permissible to use some form of torture on this single individual this one time if it would save lives? And in your mind, you don't have to tell me the answer, you don't have to post it or anything, but in your mind, pick one. Would it be yes, or would it be no? And this is it's a very unique scenario. It's called the ticking time bomb scenario. So this scenario actually, it's real. It's not just fake, something that I just made up. So this has some kind of an appeal. So a very famous social commentator and legal scholar by the name of Alan Dershowitz, he argues that a vast majority of Americans would in fact expect law enforcement to use any means necessary to obtain information necessary to prevent a terror attack. Would you? Again, think about it. And in this scenario, Dershowitz proposed the creation of something that's kind of interesting, called a torture warrant. Now, we already know the application of a warrant, like a search warrant and an arrest warrant. We've covered that. But what about the creation of this torture warrant? Now, it can only be issued by a judge in cases where, one, an absolute need to obtain this information is immediate, and two, there is probable cause to believe that this person has this information, and it could lead actually to some aspects of immunity to the person who's giving you the information, of course, under duress, under this ticking time bomb scenario. So what do you think about that? Are there procedural issues in that? Yeah, some of you are probably thinking, wow, that's a little bit much. That's way outside the realm of a search warrant or an arrest warrant. But I wanted to throw that out there because, in these times, these times of terrorism or counterterrorism, would this be a possibility in your mind? So, kind of the guidance of electronic surveillance, if you will, is going to be the Foreign Intelligence Surveillance Act. And this is called FISA. And FISA provides procedures for electronic surveillance of threats to national security. And it was also extended in 1994 to cover physical searches of dwellings and other structures. So again, kind of an interesting act, if you will, and it's actually you can look at the document. So in 1976, the Senate Select Committee to study governmental operations with respect to intelligence activities issued a report that documented widespread warrantless spying on Americans by U.S. intelligence agencies. And this surveillance activity was based on national security. And therefore, sometimes there was no need for a warrant or a court order. So remember, what is needed to get a warrant? This means that these searches or these warrants were obtained with less than, let's say, probable cause. So let's just kind of keep that in mind. So in 1978, in reaction to some of the different rulings regarding obtaining information without court orders, and the claims that were brought forth, if you will, U.S. Congress enacted the Foreign Intelligence Surveillance Act, or FISA. And again, this is to provide procedures for electronic surveillance of threats to national security. And later on, in 1994, FISA was extended to cover physical searches of dwellings and other structures. Now, keep in mind that FISA regulates surveillance within the United States of international threats to national security and of international terrorist activities. And FISA also addresses the surveillance of Americans and American residents abroad. It does not regulate the surveillance of non-U.S. citizens and of non-U.S. residents outside the United States. So, kind of continuing with our discussion on FISA. So now you kind of know what FISA is. So FISA established the Foreign Intelligence Surveillance Court, or the FISC, which comprise 11 federal district court judges selected by the Chief Justice of the United States and by 3 other federal judges. And the laws here were intended to increase counterintelligence capabilities and also establish procedures for the judicial authorization of foreign intelligence surveillance. So basically, requests for a warrant to conduct surveillance of a threat to national security, or for a warrant to conduct surveillance involving international terrorism, they are filed through the FISA court. And the court is typically, it's usually one judge, and that kind of rotates. So that's kind of the Foreign Intelligence Surveillance Court. So again, it's comprised of 11 federal district court judges. They are selected by the Chief Justice, and any request for a warrant to conduct surveillance of a threat of national security, it needs to be filed before this single judge. Now, one of the other controversies that's kind of out there is that all of these proceedings are secret. which is different from what we are looking at, or what we've been used to looking at, right? Other court hearings, they're not secret, and they're not secret for a reason. But if you kind of think about it, why do you believe that the proceedings need to be secret? Well, I think if you really kind of think about it a little bit more, the proceedings and the orders of this court are secret, and the target of the warrant is not represented at the hearing. And government lawyers, when they do this, they're still required to satisfy certain conditions to get a FISA warrant. But I think the secrecy part is so there's not leakage of information that kind of goes out to everybody. And if you want to know more about, say, national security and the National Security Agency and the FISA court, etc., I've got a couple of videos for you here. But here are the 4 conditions that are needed to be satisfied in order to secure a FISA warrant. So 1 is the target. The government must demonstrate probable cause that the target is an agent of a foreign power or a member of a terrorist organization. So again, the target may be a U.S. citizen, resident, or foreign national. And the so-called lone wolf terrorism provision that was added by the Patriot Act authorizes the surveillance of non-U.S. residents who are not agents of a foreign power or affiliated with an international terrorist organization, but who are engaged in international terrorism or in activities in preparation to terrorism. So that's the target. Next would be probable cause. So the government, again, is required to meet a little bit of lower probable cause standard than that used in ordinary criminal court. FISA orders are based on the probability of a possibility that the target of the order may engage in activities threatening national security or may engage in terrorism. So you can see it's a little bit looser than a standard search warrant that is strictly probable cause. So here it's a little bit less. The next one would be purpose. The primary purpose must be to investigate a threat to national security or a threat of terrorism. And then finally would be place. The place or communication device targeted for surveillance must be being used or is about to be used by a foreign power or terrorist organization to carry out activities that threaten national security. So those are the 4 conditions that you need in order to obtain a FISA warrant. So a little bit more on FISA. Again, FISA warrants are generally easier to obtain than warrants for ordinary criminal investigations because they require the standard requisite or burden of probable cause. And again, the reason it's a little bit less is because of national security. And of course, fearing that or fearing a relaxing of standards for FISA warrants to pursue criminal investigations in those circumstances in which probable cause was lacking, the government came up with kind of an interesting little word here, if you will. And what we're going to talk about now is a interesting concept, and it's called the wall. So the wall is actually the separating the individuals investigating national security and those engaged in criminal activity. So I gave you kind of a little bit of a read right here. The practice eventually became a policy, and a policy that was reduced to writing by DOJ in 1995, and it was commonly referred to as the wall, and this is in FISA. And again, it basically is meant to separate those individuals investigating national security and those engaged in criminal, investigations. Now, one of the inescapable consequences of the wall was the inhibition of the sharing of information between the intelligence and law enforcement communities. So these are some issues, but to kind of get around the issue, to make sure that we're not using FISA warrants to just not just look at terrorism, but to look at regular criminal activity, they've formulated, again, the wall, and you kind of get the gist of what the wall is. Okay, so let's look at some different types of electronic surveillance, and these are things that you'll look at, or you might even see during some investigations, but typically they're used in order to monitor individuals, especially in this case regarding terrorism. So, first of all, understand that FISA warrants are necessary for both electronic surveillance and physical searches that are directed against foreign threats to national security and international terrorism. And the government is required, if possible, to provide the FISA court with the identity of the individual to be targeted for surveillance, as well as with the facts and circumstances that justify the surveillance. Now, an American citizen or resident of the United States may not be singled out for surveillance based on the exercise of his or her First Amendment rights. The standard is whether there is probable cause to believe that the target is an agent of foreign power, is affiliated with a terrorist group, or again is engaged in terrorism. So the government must demonstrate the probability of a possibility that the target of the warrant may engage in activities that threaten national security. Okay, so with that said, again, let's kind of jump into now some of the things that are used. So pen registers are typically deployed to record telephone numbers dialed from a phone, and a trap and trace device, those record the numbers of incoming calls. It's kind of an interesting thing. So Section 214, and if you've never seen what a trap and trace device or a pen register looks like, you have some photos there. Section 214 of the Patriot Act states that an application to install one of these devices requires an investigator to certify to a court that the information likely to be obtained is relevant for any investigation to obtain foreign intelligence information or to protect against international terrorism or clandestine intelligence activities. And the target of the surveillance is not required to be a suspect in an investigation of national security or terrorism. And the investigation may not be conducted solely on the basis of activities protected by the First Amendment to the Constitution. Now, Section 216 of the Patriot Act extends the standard for the use of pen registers and trap and trace devices to include the capturing of email. So here we have another electronic surveillance device besides a pen register. You know what that does, and now you know what a trap and trace is, but does it extend to email? So the Patriot Act also addresses search warrants for the content of stored voicemail and email. The government may also delay notification of the search of email and voicemail in the event that notification is likely to have an adverse impact on the investigation. And there's a lot of sections. You don't need to know the section numbers. You just need to know that the Patriot Act will also allow an investigating officer to get voicemail or email. So Section 220 authorizes a federal court order to issue a nationwide search warrant for this type of stored data. So, again, you have some interesting other aspects here. So again, talking about email and even the addresses of web pages downloading during internet browsing. So the contents of the communication, which would be email or the web page, these are things that we can also look at, and they can be part of the warrant. So what about a roving wiretap? So Section 206 of the Patriot Act authorizes courts to issue what we call roving wiretaps, or for what is termed to be multi-point surveillance. And this provision permits the electronic surveillance of several things like telephones or computers or other devices that are used by an individual without requiring that law enforcement obtain a separate warrant to monitor each phone or computer account or other electronic device that is utilized by an individual who is the target of the investigation. So you can get one warrant that covers everything. This provision is a response to the fact that terrorists regularly discard cell phones or switch between various devices in order to avoid surveillance. Now, in 2006, Section 206 was amended to require that the government provide details regarding the identity of the person to be placed under surveillance and to require law enforcement to notify the court when the surveillance shifts to a new communication device that was unknown at the time that the warrant was issued. So you can still use the roving wiretaps, but there's a couple of other steps that you have to take because of the amendment. Okay, and then finally would be emergency electronic surveillance. So electronic service providers, like internet providers, when contacted by law enforcement, may voluntarily disclose stored communication information in an emergency situation involving the risk of danger or death or the imminent risk of serious physical harm. And if you kind of say, well, how does this really relate? Think about the terrorist incident that happened in San Bernardino a couple of years ago with the husband and wife team. And when they found the suspects and they engaged in the shooting of the suspects, and when they were able to get the suspect's phone, there was a big issue on the opening of the phone because the FBI and law enforcement went to Apple to ask them to open the iPhone, and they refused to do that because they didn't want to give away trade secrets, if you will. So again, there's a little bit of a debate on that, but just know that when contacted by law enforcement, these service providers may voluntarily give you that electronic communication information under emergency where there's a risk of danger or death. Okay, so now here we're going to talk about sneak and peek search warrants, and this is kind of a controversial thing. But think of it in the term of terrorism. So Section 213 of the Patriot Act provides for what is termed an anticipatory warrant or sneak and peek. And I think sneak and peek sounds cooler, but the proper legal name is an anticipatory warrant. So a sneak and peek warrant authorizes law enforcement to delay notifying an individual that they have conducted a search. And law enforcement officers carrying out sneak and peek searches do not have to leave a copy of the warrant or even a receipt indicating the material that they had looked at inside of the location that they were going into. Now, where there is evidence of criminal activity, the police typically then return with a warrant and execute a search and formal arrest warrant. So these types of searches they're typically conducted in isolated instances in the past, primarily for narcotics offenses, etc. So, I mean, think about this before we kind of go on. These types of warrants, they authorize law enforcement to delay notifying a person that they've gone in and conducted a search. And as with a typical search warrant, law enforcement does not have to leave a copy of the warrant or a receipt, because then, of course, the person would know that law enforcement had searched. Does that kind of make sense? So you can start to see maybe some issues. So Section 213 for the first time creates specific statutory authorization for these types of warrants, these sneak and peek or covert searches, if you will. And these searches, again, are not always directed at terrorism investigations, and they apply to all types of criminal investigation. And of course, providing notice, if we gave notice, that would definitely result in an adverse issue, right? Because the person would know that they were there. And that adverse result could endanger a person's life or their physical safety, or facilitate the suspect, they might flee, or even risk destruction or tampering of evidence, and even risk intimidation of potential witnesses and just overall jeopardizing the investigation. So, so for the first time, we do have some statutory authorization, but, again, providing information to the suspect, like leaving a receipt or letting them know they were subject to a search, could be detrimental. Now, one of the other things that has to happen in order to apply for a sneak and peek warrant is that law enforcement has had to have tried all other means. So you have to have used every other means that you can think of before the judge is going to allow for a sneak and peek warrant. Now, critics of the sneak and peek would argue on a couple of areas, and one would be probable cause, stating that this needs to be the standard. Number two would be in the realm of terrorism, that these sneak and peeks should be limited to terrorism only. Next would be the 30-day notice. You don't have to notify anyone until 30 days, and the critics basically think that 30 days is kind of long. That's too lengthy of a period of time. You should have to notify the individual that they're under surveillance or the subject of a search faster than that. Next would be accountability. There is no way to track if police entered the correct home and really what they did. And then finally would be judicial review. Without probable cause, judges typically would really not authorize this. I mean, if you think about it, there's little likelihood that a court would find that a prosecutor has failed to establish grounds to conduct a sneak and peek search, given the broad basis for approving these types of searches. So again, as we talk about it, there are critics, but can you see it as a possible tool as it relates to terrorism? And sneak and peeks fell under the USA Patriot Act and also the Freedom Act. So if you want to watch a little couple of videos on sneak and peeks, I've got some information here that you can look at, a couple of cool videos talking about sneak and peek, and even a little piece of what a sneak and peek warrant actually looks like. So now we're going to move on to detention of non-citizens. So Section 412 of the Patriot Act provides that a non-citizen may be detained for 7 days without being charged with a criminal or immigration violation. And the Attorney General of the United States must certify that there are reasonable grounds to believe that an immigrant is a terrorist or in fact has engaged in terrorist activities. So there are some rules set forth in this, and again, this is another controversial type issue, but it's under Section 412 of the Patriot Act that allows you to detain somebody in the investigation of terrorism. Same would be with what we call a material witness warrant. The federal government enacted the material witness law in 1984 to enable the government to arrest a witness whose testimony is material to a grand jury investigation or to a criminal prosecution, and who may be unavailable at a later date to testify, or who may flee in order to avoid testifying. And individuals, of course, are to be released following their testimony. So here, the government is able to arrest a witness whose testimony is material to one of these two investigations, and who may be unavailable at a later date, or who may flee in order to not testify. And of course, again, they are released following this testimony. Now, the Department of Justice has reported that every individual detained under a material witness warrant has been found to have relevant information. And the allegation is made that material witness warrants have been used in terrorist investigations to detain individuals who themselves are being investigated for terrorism. Now, it is true that a number of individuals who ultimately were prosecuted or detained on charges of terrorism initially were detained as material witnesses. And this really isn't surprising, because the individuals detained on these material witness warrants often are themselves engaged in that terrorist activity. So material witness warrants have been, again, subject to criticism, like a couple of these things have been that we're talking about. And several reforms have also been proposed. And one would be limits on the length of detention. You know, there should be limits on the length of detention. Next would be flight. And the government here should be required to establish with a near certainty that unless they're detained, an individual is likely to flee or to be unavailable to testify. And then finally, information. Individuals detained should be informed of the reason for their detention and should be informed of their right to an attorney to challenge this arrest or detention. Now, material witnesses do enjoy the same constitutional right to pretrial release as other federal detainees, and federal law also requires release if their testimony can adequately be secured by deposition and if further detention is not necessary to prevent a failure of justice. So you can see how these warrants might serve their purpose and how there might be some controversy. So next would also be the monitoring of what we call attorney-client communication. So in October 2001, Attorney General at that time, Ashcroft, issued an order permitting the Federal Bureau of Prisons to monitor attorney-client communication when the U.S. Attorney General certifies that reasonable suspicion exists to believe that a pretrial detainee or an inmate may use communication with attorneys to further or facilitate acts of terrorism. So, this is controversial as well, right? So under attorney-client privilege, to keep communications confidential, it does not apply where communications are intended to facilitate criminal acts or a conspiracy to commit a criminal act and are not related to seeking or providing legal advice. Now, they can also be undertaken without a warrant, but it also required notification to attorneys. So, yeah, there's some controversy probably built into this one, right? So this monitoring, again, they can do this without a warrant, but the government is required to notify the lawyer and the client that their communications may be monitored where reasonably necessary to deter future acts or violence relating to terrorism. So, and again, the thinking behind the order is that attorney-client privilege to keep communication confidential does not apply when communications are intended to facilitate criminal acts or conspiracies or to commit criminal acts that relate to terrorism. So just, you can kind of look at it there. Okay, so what is our strategy then? What about, again, we'll talk about another issue that could fall into the realm of criminal procedure. This would be the terrorist screening database or the watch list. So the terrorist screening database is compiled and administered by the FBI Terrorist Screening Center. And this watch list includes roughly about 700,000 names and includes 8,000 Americans suspected of ties to terrorism. And here individuals are grouped in various categories of seriousness, and roughly 47,000 individuals, 500 of whom are Americans, are categorized as reasonably suspected of terrorism or are known terrorists and are in fact prohibited from flying. And individuals who are considered less of a threat are subject to additional questioning or even enhanced physical examinations before they board any type of aircraft or transportation, specifically air. Now, the terrorist screening database is kind of a one-stop shop that is used by all federal and state agencies to screen individuals crossing borders into the United States or applying for visas to enter the United States. And individuals are not informed that they are on the list, to keep terrorists uncertain whether they may be stopped or questioned. Now, critics of this complain that the list includes misidentified individuals, those whose names might be similar to a known terrorist and who are without connections to terrorism. And, and these individuals, of course, may apply to have their names removed from the list, but this is the terrorism watch list. Now, kind of along with the counterterrorism strategy, both the Bush and the Obama administration have invoked what we call the state's secret doctrine roughly 100 times since 2001 to prevent legal actions against U.S. intelligence officials and other intelligence-related organizations. Now, the state secrets doctrine permits the U.S. government to intervene in any civil case and to ask the judge to prevent the presentation of evidence that would in fact damage the security of the United States. And the state secrets doctrine has been relied on in several occasions to exclude evidence in actions brought against individuals who allege that they were unlawfully detained and abused. And you can actually look at this doctrine in a kind of a PDF document if you'd like to read a little bit more. How about drones? So I'm hoping that you can see that a lot of this ties into criminal procedure because there are issues that kind of relate to all of this. So drones are small, kind of remote operated, pilotless aerial vehicles, which have become very important, and they are an important weapon in the war on counterterrorism, and it's part of the U.S. strategy. And estimates are that in Pakistan alone, let's say between 2004 and 2012, as many as 2,295 individuals were killed, including most of the top leadership of Al-Qaeda. Now, an unfortunate aspect of reliance on drones is that roughly 17% of the victims were not found to be active Al-Qaeda operatives. Now, the Obama administration disputes the claim that non-militants who are in the vicinity of drone strikes have been the victims of drone strikes, and it claims that only a handful of innocent individuals have been killed in these types of attacks. And international law recognizes that the infliction of collateral damage is justified when the importance of a military objective outweighs the injury to civilians and damage to civilian property. So there's, you can see that there are, while they might be an okay, a good tool to be used in counterterrorism, there can be some issues, just as there's going to be some issues as it relates to enhanced interrogations. So one of the most controversial aspects of U.S. counterterrorism policy has been the use of enhanced interrogation techniques to question high-value detainees. And one of the most controversial aspects, again, is the use of these enhanced techniques. Now, President Bush at that time made the critical determination that members of Al-Qaeda who were not apprehended by American forces were not entitled to the protections that were provided by the Geneva Convention. So, again, this is a very controversial type thing, right? Instead, these individuals were considered to be what we term enemy combatants, who were treated humanely but were not entitled to those same rights guaranteed to prisoners of war or to the protection of ordinary, civilians. So this debate, again, has gone on for a long time, and it continues to center a lot of times on the questioning, again, of these high-profile operatives, several of, and at this time we're talking kind of maybe around 9/11, those of whom were, integrally involved in the planning of 9/11 attacks against the World Trade Center and the Pentagon. And following these particular attacks, military interrogators were in fact under pressure to collect intelligence on Al-Qaeda's plans. And because of that, interrogators were authorized by officials, again in the Bush administration, to use various coercive techniques, things that might be, like round-the-clock interrogations, or stress positioning, or the use of dogs, or isolation up to 30 days, and even sensory deprivation, music and things like that. And even more coercive techniques could be employed with the approval of high-ranking government officials. And these practices would include threats of violence, or exposure to cold weather, or the use of water in waterboarding, which, if you don't know what that is, it entails the pouring of water over an individual's face, and you have a covering over their face, and it kind of simulates drowning. So, again, these are very controversial type things. And we're not going to go too in depth. I just want you to understand their nexus, if you will, to criminal procedure. So again, and we talked about these a little bit too. So there's a photo of waterboarding if you've never seen it. And then along, in 2005 came about the Detainee Treatment Act. And this is where the U.S. put a halt to most of the enhanced interrogation techniques. And if you want to look at the act, you can see it right there. And then finally, we're going to look at military commissions. So the Supreme Court in 2006, in a case called Hamdan versus Rumsfeld, the U.S. Supreme Court considered a challenge to military commissions filed by Hamdan, who was a Yemen national detainee in Guantanamo Bay. And he had served as a bodyguard and personal driver for Osama bin Laden. And he was charged with transporting weapons as part of an Al-Qaeda conspiracy to commit acts of terrorism. And he was subsequently indicted and scheduled to stand trial before a military commission. And he claimed that the military commission procedures failed to satisfy the requirements of due process. Now, in here, the Supreme Court approvingly noted that President Bush's order establishing military commissions provided for a number of protections for the accused. The court, however, held that these military commissions possessed several flaws, and one was exclusion from trial. The accused and his or her civilian counsel may be excluded from the trial and denied knowledge of the evidence against him or her when the information may jeopardize the safety of witnesses, result in the disclosure of the identity of informants, or jeopardize national security. The accused also may be denied access to sensitive information so long as the judge concludes that this will not deprive the defendant of a full and a fair trial. Next would be failure to follow rules of evidence. Evidence may be admitted that would have probative value to a reasonable person, and this may result in the admission of hearsay and evidence obtained through coercion. Next would be limited appeal. An appeal may be taken to a 3-member review panel appointed by the Secretary of Defense, but only one panel member is required to have experience as a judge. And the review panel makes a recommendation to the Secretary of Defense, who in turn refers the case to the President for a final decision. So we know that there are some flaws, but the military tribunal type or commissions are a little bit different. And so there are different rules. So what we have in 2006 is the enactment of the Military Commissions Act. And this provides military commissions with issues related to due process. So they must follow due process. And if you want a little bit more information on this, you can look on page 585. And then finally, we're not going to watch the video because we're just about at the 60-minute mark, but I'd like you to take a look at the Jose Padilla case. Because remember at the beginning, as we were talking about the fact that the United States, is still, the challenge is to strike the balance, again, between combating the threat of national security and protecting civil liberties. And also noting that in striking this balance in certain times of emergency and war, that the courts do have and have kind of held that the protection of the country must take precedent over individuals' rights, and thus there is a little bit of lessening some of the rules, basically to sacrifice some of those liberties in order to meet the challenges of homeland security. So take a look at the Jose Padilla case, and then kind of think about whether or not you thought what happened in that particular aspect was in fact proper or not. Okay, so with that being said, that's going to conclude our chapter 15 lecture on counterterrorism. Again, take a look at some of the videos. I think they will help you add a little bit more context to the issues, but I'm hoping that you can see that a lot of these different things that we spoke about today do have a direct nexus or connection, if you will, to criminal procedure. And I hope you were able to learn something from this chapter. So with that said, again, this concludes our lecture on chapter 15 on counterterrorism.